Hello everyone, and welcome to the Caselaw Minutes Civil Series with Litigation Help. My name is Victor, a student at Osgoode Law School, and today I will be analyzing Ali and Ford, a 2014 case in the Ontario Superior Court of Justice. Just a quick fun fact, the Ford in this case is actually former Toronto Mayor Rob Ford, along with former Toronto Chief of Police William, we know him as Bill Blair, and the City of Toronto. Just a quick disclaimer, this presentation is for general legal information only, and for advice specific to your case, please consult a lawyer. So before we get into the facts of the case, you might notice that the term endorsement is placed right before the first paragraph if you've searched up the case. I've also attached an image from the case on Canly as a visual aid. An endorsement is basically a written record of the court's decision on a motion. So as we go through Ali and Ford, the case is actually an endorsement, which outlines what the judge has decided and why. If you're interested in learning more about endorsements and other court orders, feel free to search the link on this slide to access another litigation help video that will go into further detail. It will also be in the description of this video. Now let's move to the facts. In December 2013, police and a nurse visited Ali's home because he had sent a letter entitled "Warning to all police personnel, government agents, and any other public servants, to police and others." With the letter, Ali attached a fee schedule, which apparently entitled Ali to fees from those who received the letters. The fee schedule basically allowed Ali to claim he was owed 60 million in US banknotes or a Canadian equivalent, so lots of money. In Ali's statement of claim and affidavit of fact, he claims he is not a subject of Canada. Basically, Ali is claiming that Canadian law does not apply to him because he is of the Moorish National Republic. In his statement of claim and affidavit of fact, he uses references from the US Constitution, US statutes, and US case law, which all do not apply to Canadian courts. Now, how did the court respond? In December 2014, by endorsement, Justice Myers directed the court registrar to send a notice in Form 2.1a to Ali. Ali doesn't respond to the form at all. Form 2.1a provides notice to a party that the court is considering to stay or dismiss their claim, unless the party responds with a written submission within 15 days of receiving the notice. A stay stops or pauses the judicial proceeding, and a dismissal would terminate a judicial proceeding. Justice Myers, in paragraphs 9 and 10, also makes clear that all persons before our courts are equal and have protection under the Charter, but no one has a right to just create their own legal order, whether in good faith or in an attempt to tie up the courts and government officials. Additionally, Justice Myers refuses to engage in legal argumentation with Ali because his arguments are nonsensical and not grounded in Canadian law. This case is actually an example of an organized pseudo-legal commercial agreement, an OPCA. In the very long and detailed decision in Beeds and Meads, the Alberta courts took a deep dive into OPCA claims. According to the Alberta court, OPCA litigants employ a collection of techniques and arguments promoted by gurus to disrupt court operations and to attempt to frustrate the legal rights of governments, corporations, and individuals. The Alberta court compared the gurus to medieval alchemists who sold their services through theater and not through results. Courts do have tools to address the issue of OPCA litigation. For example, they can strike and dismiss claims using the powers granted to them from civil procedure legislation. They can use punitive damages to dissuade what the court considers extortion-based OPCA litigation. Punitive damages are ordered by the court with the goal of punishing a specific party. Courts can award the innocent party damages in an OPCA claim by making the party using OPCA tactics pay extra in cost to the innocent party. In this specific case, Justice Myers finds Ali's claim to be frivolous, vexatious, and an abuse of the process, and dismisses it. He uses Rule 2.1 of the Rules of Civil Procedure. The rule allows a court to make an order staying or dismissing a proceeding that appears on its face to be frivolous or vexatious or otherwise an abuse of the process of the court. Rule 2.1 gives parties who assert OPCA arguments one fair opportunity to try to advance an argument in a manner consistent with Canadian law. In this specific decision, that chance was the Form 2.1a, which was mentioned earlier. Additionally, just as a side note, there have been further amendments to both Rule 2.1 and 2.2 to make it even easier for courts to dismiss these types of claims. So the rules of civil procedure don't actually provide a definition on what is considered frivolous, vexatious, or abusive. Therefore, I decided to search for some definitions from other sources to try to clarify as much as I can these three terms. A frivolous claim is one that lacks a legal basis or legal merit. It is manifestly insufficient as a matter of law. Vexatious is defined as as of conduct without reasonable or probable cause or excuse. It can be harassing and annoying. 140 sub 1 of the Courts of Justice Act defines a vexatious litigant as a person that persistently and without reasonable grounds instituted vexatious proceedings in any court or conducted a proceeding in any court in a vexatious manner. Finally, abusive is characterized by wrongful or improper use. So when we take it together, we can say that OPCA claims are frivolous, vexatious, or abusive because 1. They lack a sufficient legal basis, 2. They seek to harm courts and other parties, and 3. They are commenced and proceed wrongfully. I've outlined 3 general takeaways from their discussion. They aren't really focused on this specific case and its facts because the broader principles are more important. The first is that Canadian courts are more than willing to stay or dismiss claims from OPCA litigants. The Meads decision also referenced the need to protect those targeted by OPCA litigants, minimize the waste of precious court and state resources, and to send a clear message these schemes will not work. Secondly, Ontario courts have been provided more powers through statute to deal with OPCA claims faster and more efficiently. That was mentioned with the statutory amendments. Finally, OPCA claims like the one by Ali are not well received by Canadian courts, and we can say confidently they will fail. Ali and Ford is a short read. It's only 14 paragraphs and it fits 3 pages. So if you want to check it out, the Canley link is on the screen now and will be in the description of the video. And with that, thank you for watching this Case Law Minutes video on Ali and Ford. We hope you will subscribe to the Litigation Help channel and feel free to check out the Litigation Help shop in the link in the description of this video. Thank you and hopefully you enjoyed. Until next time, bye-bye.